Very warm good evening to all. The topic today is of utmost importance, that is special leave petition. Now, this is something which is regular before the Honorable Supreme Court, and it is said that Supreme Court breathes in and breathes out through the special leave petition. Now, what is special leave petition? If you go to Article 136 of the Indian Constitution, you will have a definition which will say any order is appealable before the Supreme Court by way of a special leave petition. Now let's go to the definition. This is very important part. Now, if you read the definition, this notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment. See, the word is any judgment, decree, determination, that is any order determined, sentence, that is conviction, or order in any cause or matter passed or made by any court or tribunal in the territory of India. Now, see, they have included tribunal in the part 1. Now, if we go to the part 2, nothing in clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal considered by any law relating to the armed forces. Now, when we say armed forces, it is the Army, Navy, and the Air Force. They have their special tribunal, which is subject matter of another lecture. We will discuss some other day. Now we will deal here with the 136 article. Now, as you have seen the definition of the article 136, it covers the civil, criminal, and the constitutional matter. Now, normally, as per the definition, any order is appealable by way of a special leave petition before the Supreme Court. But the court says if you have an alternate remedy, that is, you can go to the High Court, then you come to the Supreme Court. It is always better because you have exhausted all the remedies. So, though the Article 136 allows you to directly go to the JMFC court or the session court directly to the Supreme Court, it is not advisable. When they say you have an alternate remedy, please exhaust all the remedies, then come to the Supreme Court. Because Supreme Court and High Court are courts of record and also the Constitutional Court. So they are meant to decide the main constitutional matters. Now, what happens if there is an order which you feel, or as a lawyer you feel it has to go directly to Supreme Court because there is grave error of law or injustice caused, then you can approach the Supreme Court directly. And in few cases, Supreme Court has entertained also. But then always it is a High Court order which is rejected, and then you go to Supreme Court. Now I'll give an example to all of you to understand. Suppose an anticipatory bail is preferred before the session court. It is rejected. Where do you go? From there, you go to the High Court of that particular state. From there on, you go to the Supreme Court. Now, once the High Court rejects the anticipatory bail, you do not file the anticipatory bail before the Supreme Court. You appeal to the Supreme Court for a special leave to your bail application, that is by way of a special leave petition. So it will be a type of bail application, but it will be called a special leave petition. You can never say that my bail application is pending before the Honorable Supreme Court. It will be a special leave petition. So any order which you are challenging from any High Court of the state, it is called special leave petition. So I'll make it very clear that special leave petition is an order which is challenged from the High Court order, and it is always called a special leave petition. Now, how do we file this special leave petition? Can any lawyer go to the Supreme Court and file this special leave petition? No. Supreme Court has a system through which they accept the special leave petition. They will not accept this special leave petition by any lawyer. There is a system of advocate on record. Now, this advocate on record is a person, is a lawyer who has cleared the advocate on record exam. And those who have cleared this advocate on record exam, they are actually there on the website of the Honorable Supreme Court. And you can approach any of your known advocate on record, and you can file through him or her that advocate on record. There is a system of advocate on record. The reason is that in case you are from the Madurai and the matter is called out before Supreme Court, then Supreme Court cannot keep on going asking. This is the understanding that the lawyer has not come from Madurai, who will argue the matter. So the advocate on record is responsible to file the matter, to remove the objection, to argue the matter, and to assist the court. Now here, what happens? The question comes whether Vandana Chaudhary, who is also a lawyer, and she gives one matter to file in Supreme Court. And she said, I understand the matter better. Can I argue the matter? Yes. Even a one-day lawyer, one day practice lawyer can also argue the before the Supreme Court, but he or she cannot file the matter. They cannot file the wakalatnama. The wakalatnama is advocate on record. The pleadings, the documents will be signed by the advocate on record. With the advocate on record permission, you can argue the matter. And then you will be, Vandana Chaudhary madam will be called the arguing counsel. So normally it is the arguing counsel or the senior, designated senior also, they can also argue the matter if they are appointed. So the filing before the Supreme Court of the special leave petition will be done by the advocate on record. Now, many people ask me how you become an advocate or record. The simple thing is that you have to practice 4 years, any court practice, 1 year before the Supreme Court training under an advocate on record, clear the exam, and once you become an advocate on record, even you can file your matters there. That is Delhi Supreme Court. Now, what happens in the special leave petition? How does it go? Special leave petition, normally the hearing is very for brief, short period. What is where you have to show to the court where the High Court has committed an error, where the High Court has gone wrong. So you have to challenge an order of the High Court, and you have to show to the court this is where the High Court has gone wrong, and this is what the point. This is a judgment. It is covered by the Supreme Court so and so judgment, or there is a mistake, manifest error in the matter. So there are so many things which you will learn in the special leave petition once you go through many judgments also of the recent. So every order which is challenged from the High Court is by way of a special leave petition. And which are the orders? It is given in the Article 136 of the Constitution. Now, there are some cases where it is a jurisdiction also. Now, see what happens. The armed forces are excluded from this special leave petition. There is a reason behind it, which is given in the Armed Forces Act. Now, the armed forces, they have a tribunal. Once the tribunal rejects their matter, they go to the Honorable High Court, that is the under the writ jurisdiction. So actually, it is totally different for the Armed Forces Tribunal. Recently, one judgment of the Supreme Court came, which was speaking about the adultery in the armed forces. Now, if everybody knows that adultery is no more a criminal offense, right? Under the criminal law in India. But for armed forces, it is still a criminal offense for the reasons differently written in the their constitution and their laws under the armed forces. So for armed forces, actually, it is still an adultery offense. So why the armed forces are excluded? There is a reason for that. There is a matter of discipline and Army Act and so many things. So special leave petition is one of the thing you should know, those who want to in future go before the Supreme Court. Also, when it happens that your order is rejected, your case is rejected by the Honorable High Court. Now, next comes how do we draft the Supreme Court special leave petition? If you, sorry. If you have seen any of the Supreme Court leave petition, there are only 8 paragraphs. If there is no interim leave, it can be 6 paragraphs also. So they 1 to 8. There are particular fixed paragraph. Under this paragraph, you can have A, B, C, D or sub paras 1, 2, 3, 4. But there will be only 8 paragraphs. Those who have gone through my book, they will know I've given few SLPs also there. My drafting book. Now, when you why this is the reason that there are only 8 paragraphs. The reason is that when the Supreme Court judge wants to see where are the grounds from which High Court the appeal has come, where are the prayers. So the court will not just plunk the papers like this. They will go through the particular para. You can show. So it is actually a systematic approach by way of advocate on record to get it filed, to get it argued also sometime. So, and it is the responsibility of the advocate on record who has to argue the matter in case the arguing counsel does not come. And Supreme Court is like mini India where lawyers from all the states comes. If they cannot travel for any reason, then it is the duty of the advocate on record to argue the matter. So this is what in nutshell the special leave petition. Now we move to the another section. Vaishnavi, unmute yourself. There are two small judgments I'll be sharing with you. Wait.
Should I start?
Wait. The first one is on the anticipatory bail in Arms Act. Vaishnavi, you're able to see?
Yes, ma'am.
Yes. Little louder.
Okay, ma'am.
Your voice is low. Can you raise the voice of your tablet or laptop, whatever you're using?
Yes, ma'am.
Yes. Thoda or louder. Very good.
Okay, ma'am.
Good. Very good. So people can hear it.
Okay.
Yeah. You can start from here.
Okay. Supreme Court, in an application filed by the appellant seeking anticipatory bail in case registered under Section 126, 115, subsection 2, 109, 352, read with Section 3, subsection 5 of the Bharatiya Nyaya Samhita 2023 and Section 25, subsection 1b, clause A, section 26, 27 and 35 of the Arms Act 1959, the division judge bench of M.M. Sundresh and Nongmenkom Koteswar Singh granted anticipatory bail to the appellant after considering the submission and the fact that cross case had already been previously registered by the appellant's mother in pursuance of a civil land dispute. In the present case, as per the prosecution on um, 2nd August 2024 at about 2 a.m. In the night, the appellant, including his other family members, arrived at the informant's house, abused and assaulted the informant and other family members. The appellant also carries firearms which he used to fire upon the informant and other family members. It was further alleged that the police recovered live cartridge, one shell of bullets, and one fired bullet at the place of occurrence. The appellant filed an anticipatory bail in High Court, wherein submitted that due to a land dispute he had been falsely implicated, and the story is fabricated. As per the appellant, the allegations of firing is fabricated as no one sustained any firearm injury, and the informant, along with others, were already inside the house during the alleged incident. He further submitted that a counter case was lodged by the appellant's mother against the informant and others for the occurrence which took place prior to filing of a FIR. However, the anticipatory bail application was rejected and thus the present petition is filed. The court noted the submissions and that a cross case has been registered by the appellant's mother in persons of civil dispute. Accordingly, the court set aside the impugned order was set aside and granted anticipatory bail to the appellant.
This is Madras High Court judgment. Now, what we heard through Vaishnavi is it was an anticipatory bail, but here again anticipatory bail was given in a special leave petition. First, you have to file the special leave petition. Now, next is a very interesting judgment from the Madras High Court. You can start reading. Vaishnavi?
Yes, ma'am.
Yes. Just a minute.
मेरी स्क्रीन शेयर करूँ क्या मैम?
I need to. You can't see this. Just a minute.
No, ma'am.
Wait. Face to home. Wait. Now it is visible.
No.
Wait. Now the civil miscellaneous appeal.
Yes, ma'am.
Oh. Start.
This civil miscellaneous appeal, which was originally filed before the link name आहे Intellectual Property Appellate Board, Chennai, under Section 91 of the Trademark Act 1991 and subsequently got transferred to the file of this court, has been filed against the order dated 26 April 2019, rejecting the application submitted by the appellant seeking for registration of the trademark fresh, not frozen, included in Class 35. Heard the learned counsel appearing on behalf of the appellant and the learned central government standing counsel appearing on behalf of the respondent and pursued the materials available on record. The case of the appellant is that they have adopted a trademark fresh, not frozen, in respect of their goods and services involving online retail store services featuring vegetarian, non-vegetarian, processed and unprocessed foodstuff, fruits, vegetables, and grains included in Class 35. They submitted an application for registration of the trademark on 22nd March 2016. According to the appellant, they have been continuously and uninterruptedly using the trade.
Wait. I
Okay,
think
ma'am.
somebody is speaking. किसी का तो भी ऑडियो ऑन है. We cannot hear you. हाँ, वैष्णवी और किसका है? किसी का आवाज आ रहा है? No, you can start.
Okay.
Can you
According
see?
to the
Yes. Go.
According to the appellant, they have been continuously and uninterruptedly using the trademark from 22nd March 2016. The Trademarks Registry objected the application under Section 9, subsection 1, Clause A and B, and Section 11, subsection 1 of the Act. For the said objection, the appellant filed their reply on 9 March 2018. Thereafter, the objection was heard and it was refused by the impeachment order dated 26 April 2019. The Learned Counsel for Appellant submitted that the trademark for which the appellant had submitted application is no way deceptively similar to the registered mark fresh and frozen. Insofar as the existing mark is concerned, it is a word mark and it has been given for goods, wholesale and retail outlets and shops, including the services relating to distribution, trading and marketing of chicken, mutton, fish, raw, semi-cooked, food cooked, confectionery, juice and soft drinks included in class 35. It was submitted that the term fresh, not frozen, is a general term and it is just diametrically opposite to the registered mark fresh and frozen. On careful consideration of the submissions made on either side and on carefully going through the order passed by the respondent, it can be seen that there was already a registered trademark carrying the name fresh and frozen included in class 35. The appellant is seeking for a trademark fresh, not frozen, for similar product included in class 35. The application has been rejected on the ground that the trademark sought for by the appellant is deceptively similar to the registered valid trademark fresh and frozen included in class 35 in respect of identical services. There are certain principles to be considered to decide the existence of this deceptive similarity, and they are A. The nature of marks, B. The degree of resemblances between the marks phonetically or ideally similar. C. The nature of goods in respect of which they are used as a trademarks. D. The similarity in the nature, character, and performance of goods of the rival traders. E. The class of purchasers who are likely to buy the goods bearing the marks they require on their education and intelligence and a degree of care they are likely to exercise in purchasing and or using the goods. F. The mode of purchasing the goods or placing orders for the goods. And G. Any other surrounding circumstances which may be relevant. To properly appreciate the objection that was raised by the respondent, it will be relevant to take note of a trademark that has already been registered as a fresh and frozen. And the trademark that has been sought to be registered by appellant, that is fresh, not frozen. Admittedly, both these marks in respect of similar food products have been included in class 35. On a cursory look at these two marks, it can be seen that the trademark which the appellant had sought for, it certainly deceptively similar. It is not what it is not what meaning is being assigned by the words chosen by the appellant, and the determining factor is whether it is deceptively similar. The class of customers who are likely to buy the goods with their reasonable mental faculty will be certainly misled on a first look of the trademark that is sought for by the appellant. Since
Well,
the only since the
I have
only
I have a low WhatsApp group.
वंदना जरा ये कर दो ना ढूंढ के ये कंटिन्यू continue.
Since the only letters that have been added by the appellant are OT, and every other word in the mark that has already been registered is available on that website, even in the trademark that is sought for by the appellant. The same being included in a class 35 in respect of identical services, obviously the decision taken by the respondent cannot be said to be illegal, and it is clearly objectionable under Section 9 and 11 of the Act. Accordingly, there is no ground to interfere with the same. The Learned Counsel for appellant submitted that the appellant must be given liberty to submit a fresh application for a different trademark, and the same should not be rejected by citing this order. It is made clear that the application has been rejected only on the ground that the trademark sought for by the appellant is deceptively similar to an already registered trademark. Therefore, if the appellant submits application for an unobjectionable trademark, obviously it will be considered by the respondent on its own merits and in accordance with the law. In result, this civil miscellaneous appeal is dismissed with the above observation. Okay, ma'am?
Yes, yes. Good. Very, very well read.
Okay, thank you.
Okay. Now we'll go to the important part, legal vocabulary. Now, when Vaishnavi was reading these judgments, one was on the criminal side from the Supreme Court, another was from Madras High Court. Now, it was on intellectual property. The first session we had, it was about what kind of lawyers you can be. Now, today Vaishnavi read about the trademark intellectual property. This is also very fast developing career, but I would always advise that whatever comes your way as a junior, first accept those kind of briefs. In the first 5 years, today we'll be talking on the internship also. So, how in the beginning you cannot make a choice unless you're second, third generation and your father or mother already has lot of briefs and they can continue with you. But otherwise, you have to accept the brief which come. It may be matrimonial dispute, it may be criminal, civil, or a trademark matters also, or a constitution matter for that reason. Now we go to the another part. वंदना, आपको वोकेबलरी शेयर कर पाओगे क्या? मेरा आज हो नहीं रहा है. वंदना, can you share?
It's not possible. I'm trying.
Just a minute. एक minute. जस्ट मिनट, मैं करती हूँ एक बार वापस ट्राई. अभी क्या दिख रहा है स्क्रीन पे?
अभी नहीं दिख रहा है मैम, आपका ही दिख रहा है।
अच्छा, अब दिख रहा है?
हाँ अभी दिख रहा है।
हाँ, अभी जरा
यस मैम।
ये जो साहब बोल रहे हैं उनको म्यूट कर देना प्लीज।
यस मैम, यस।
हाँ हाँ, उनको म्यूट कर दो। ऑल म्यूट मत करना, मैं भी म्यूट हो जाती हूँ। मैं सुनाई दे रही हूँ? एम आई ऑडिबल?
Yes, ma'am.
यस, ऑडिबल नो, राइट। ओके, ग्रुप में वहां लिख दो चैट में कि द फर्स्ट वर्ड इज वेंडेटा. नाउ political vendetta mostly is the word we hear normally, and also we read in the newspaper. Dispute between two people or groups which last for a long time. The learned counsel for the petitioners would then argue that the petitioners have been prosecuted only on account of political vendetta. Now, next is emanate. Emanate means to produce or show something. Now, brief facts of the case pertaining to the issue as emanating from the record. Mostly charge जो होती है उससे जो emanate होता है record पे वो. So it is like a showing, to produce or show something unflinchingly. Now this is remaining firm or committed or not backing down. Stronger, I would say. He gave cogent and convincing evidence, right? Stating an unflinching manner, hmm, without backing down or weaker नहीं लग रहा था, manner about the involvement of all the three accused in the crime. Now plethora, a very large amount of something. Normally ये word होता है plethora of the judgments. The rules of the fairness and procedure have to be read into the rules and the permissible course of action in such cases as has been laid down in plethora of decisions. Now here decisions mean judgment. Plethora of decisions by the Honorable Supreme Court, which has been followed by the respondents in letter and spirit. See the words, how they are used. And we says, to think of something as being possible in the future. The protective discrimination has been envisaged under the Article 15 of the Constitution of India. Envisage is the word if you use, actually it is very impressive while arguing the matter. Now incumbent. I have also given Hindi word incumbent के लिए विद्यमान, office bearer. Or the meaning is also different. Obligatory, a person who is currently in an official position. It shall be incumbent on every police officer in charge of. If he receives information that any child is being treated with injustice or inhumanity, to make a report thereof to the district officer. Incumbent is also used incumbent chief justice, that is who was विद्यमान chief justice ऐसे बोलते हैं. Refuted, meaning is also very simple, to prove that a statement, argument, etc. is incorrect. See, here is not correct nahi likha hai, it is incorrect. PW8, that is prosecution witness number 8, has refuted the suggestion. Suggestion is put up always in the criminal practice, that he has shown recovery of Gandasa to strengthen the and support the prosecution version. Trickery, trick से ही बना है, use of dishonest method. Now the applicant has resorted to act of trickery and had taken benefit of this act of forgery. But here it is for dishonesty. Culminate. This is also very regular word to be used. Final result of any process. The present judgment is result of culmination of trial initiated on the complaint filed under section 130 of Negotiable Instrument Act. From where it is coming actually, the meaning. Cripple. Cripple means disable. The meaning itself is very clear. Now this is a long sentence, but I have given it the reason that you will know the legal words. There may be a perception that if principle of primacy is to be followed, then the right of one gets totally extinguished. Right? अब extinction बुझ नहीं, right खत्म हो जाता है. It has to be borne in mind that total extinction is not balancing. When balancing act is done, the right to fair trial is not totally crippled, but it is curtailed to some extent by which the accused gets the right of fair trial. And simultaneously, the victims feel that the fair trial is conducted and the court feels assured that there is a fair trial in respect of such cases. That apart, the faith of the collective is reposed. See, faith of the collective is reposed in the criminal justice dispensation system and remains anchored. This was all today. The words. Now, these words, even if I share the PDF, I am not sure that you can use them. The best way to use them is to start writing a notebook. You keep a 200 pages notebook, start writing 10 words each day. It will be difficult, but you make it a habit. Do not go to or retire to bed unless you write 10 words every day. And if you start writing 10 words, trust me, in a month it will be 300 words. And do not tell me that your vocabulary will not improve if you use these words. And regularly you will be using it, but it requires some time and some determination to sit down and get it done. Now, uh, one of my junior, Sangapriya, she's also intern with me. She suggested me, lot of people are not interested in doing the internship. So why don't you take up this subject? You all are now, right now, online interns with me. And let me tell you, internship is something which is more important than the practice. I will tell you why. Because while you are interning with somebody, what happens that you get to know the FIR, you get to know the charge sheet, you get to know the uh, this plaintiff's case, suit filed by, or writ petition, or the written statement. You get to know so many documents in your hand. I have met people who have not seen the FIR in life, and when they come to me directly as a lawyer, it is actually very difficult. So it's better that you start interning with somebody. Now, now with somebody means I am not trying to tell you that you find the best lawyer, you go to High Court, you go to Supreme Court. If you actually ask me, trial court lawyers are the superstar. They are super lawyers. Those who know to practice before trial court, they can stand any court, anywhere, any High Court, any Supreme Court, and they will be able to tell their case very fast. The best part is a start intern. Now, where do you start? Whether you join the company, that is also okay. But if you actually want to come into litigation, I would tell you that you start from the where your college is, just nearby place. You find a lawyer who allows you to sit in his office, to attend the court, and also to help him in the drafting work. Now, drafting is not something which you can learn in a day. So drafting something you start the day you start interning. Now, how do sometimes the senior may not give you the brief, because see, he or she, I am responsible for my case. I will not allow you to argue. Even my the immediate junior, I will wait, and I know if she or he can carry that matter, understand that matter, and get an order, because I am answerable to the my clients. Now, the interning is something which the day you start with somebody, you just request that person two things. One, give me some time to sit in your office. One, because there files will be always in the office or at the home residential office. Even if she or she has 30 files, and if you are able to read those 30 files, trust me, you will gain so much knowledge. Why so much knowledge? एक ही वकील के पास काम करने से इतना नॉलेज कैसे मिलेगा? Because that brief, that paper book, that file of a litigant is also having, if there are 30 files, there are 30 opposite lawyers whose paper will also be in those papers. So you get to know, if you apply your mind, it is like this. So you should read those papers also of the opposite lawyer. I still read the drafts by opposite lawyer to understand that I can get something good out of it. So always do one thing, that read all the files which are available in the your uh, I would say senior's office. Now, another question comes, whether it should be a paid internship, unpaid internship. I will request only one thing. Uh, I know it's difficult to survive, but Always ask for the knowledge. Don't ask for the certificates. Today I wrote also in the group. Don't ask for money. Money will come automatically. It is a matter of 3 years, 5 years course. You're still a student. You can do something else and survive. But knowledge is something which you need to get. Guru bina gyan nahi bolte na. So this in our this जो प्रोफेशन है उसमें तो हमेशा यही बोलते हैं कि यू आर ऑलवेज अ स्टूडेंट ऑफ लॉ. सो टेल दैट सीनियर जस्ट अलाउ मी टू होल्ड योर फाइल. आपको फाइल उठाने को मिल जाता है सीनियर का ना, तो काफी अच्छा है. एंड आपकी जो लगन देखेगा, इफ यू सी योर डिटर्मिनेशन, इफ यू सी योर डेडिकेशन, what he or she will do, she will allow you to give more work. And if that work you can learn in the internship, you will be the best lawyer in the first 2 3 4 years of your practice. Now, so many people ask me, where do I go for internship? One, to your nearby college. If there is a court, start going. You may not know somebody. Ask me if I can suggest somebody. I can suggest in Madurai also. I can suggest in the Harvard court also. I have visited 35 high courts in the country out of total 41 high courts, which are along with the principal bench and that other this benches also. Principal bench and the other benches like Bombay, we have Goa, Kolhapur, Aurangabad, Nagpur. Like I have visited all these places. I have few contacts. If I can share with you, possible there is nobody is ready to keep you as an intern. You have one more thing which you I can tell you. Just go and visit your nearest court. If near college, near residence, near your workplace, whenever. Even if you go for 2 hours, just sit in the court. Be in uniform, black and white. Nobody asks you. Carry your I card. It's possible. There is nobody is ready to keep you as a junior. Nobody is ready to give you internship. But trust me, if you people start seeing you every day, the judge starts seeing you every day, they will tell you, they will assign you work. They will definitely. Even the court staff will help you. This is what it happens. In my case, it has happened. In your case, also, it is likely to happen. The magic happens. So that the best practice is to go visit court, get the internship with somebody. Now, civil, criminal, I will not suggest that way. It suggest you find out somebody who has good amount of work and also has a this urge to that I can share my knowledge. He or she should be somebody who is ready to accept you. Don't force your husband on somebody else, but go and try with some people, some lawyers. It may be senior, junior. There are junior advocates who are also keeping juniors. So what's wrong in it? Because a junior lawyer also may have a good amount of work. And if you do internship, the first thing happens, your drafting improves. You get to know the clients also. I always say a lawyer has a chance to, in POXO cases, it is 8 years, 10 years children. And in other cases, it is up to 8 years. So you have to handle people from 8 to 80 years. So you have to call sometime uncle, auntie also. You have to call sometime bhai sahab also. You have to say, nahi beta, ye theek ho jayega. You have to treat your client as a child. So you are the father and mother of the your client. You have to parent them. I have seen junior 25 years old in my office and trying to counseling a lady who is 70 years old. So it is possible. You have to become mother of the client, father of the client. See, clients, sometime I hear, why can't they understand this simple thing? See, if they could have understood that simple thing, they would not be sitting in my office. They would not be coming to the court. There are cases when there are fights in the family. There are cases when there is a matrimonial dispute. You have to be kind. There are cases when I've seen people have lost the custody case and the other side does not allow the child to meet the father or the mother, vice versa, whatever the case. It is actually a very difficult situation. In those cases, you can't say I'm 25 years old, I'm 30 years old, how I'm going to handle a 50 years old man. No, no, or woman. You have to become father and mother to that. So now this counseling, this handling of clients with kindness, use this word with kindness, can only can only be done when you are actually practically present in the court. I have seen the best of the judges guiding and counseling in such a way that जो मैटर 10 साल से चल रहा है वो 10 मिनट में सेटल हो जाता है. So it is the experience of that judge who is handling 40, 50, 100 cases per day is somebody who is more wiser than us, because he is actually handling more cases. We are handling 1 or 2 cases in a day, sometimes 2 cases in a week. But the judge is somebody who is facing, if it is 50 cases or 100 cases, 200 lawyers every day, 200 cases every day, and he has a chance to see so many people from the dais. So he is in a better position. So always do remember one thing, that visiting code itself in education, and it will add to your regular course of the LLB or LLM or the 5 years course. Now, when I say how it will add a value to your course, because what you are learning in the code are the same words you will be using your writing your examination. So those who are junior with me, they actually know that while writing the paper, these all Hindu Marriage Act, CRPC old I am talking, or BNSS, all these acts will help them. And that is how. Sometimes they people used to ask me, आपको कैसे IPC, CRPC के सारे sections याद है? I will tell you how it is. As you go on working and one case comes, you remember. Now Article 136, now you have gone through that. And as we were discussing Article 136, Supreme Court, special leave petition, you'll remember lifelong. Now, I don't think I need to ask you what is Article 136. You will be able to answer anywhere, any court. So, this is what is the basic, I would say, of the internship, which makes you a better lawyer in the future. And when you come after 3 years, 5 year course, you are not just empty slate. You are full of all the knowledge, full of ideas, and also the basic practice, which how the court functions is in your knowledge, and your body also get used to when you go to the court. That is why internship is very necessary. It is not necessary to find a Supreme Court lawyer, High Court lawyer. It only thing that you need to find a lawyer who has good amount of work. Even if he or she has 10 cases, please go and meet her and him, and don't ask for any money. Just ask them to allow me to ask the knowledge. Request that he or she allow you to read the her or his files. That is more than sufficient, which will make you better lawyer. Thank you very much, everybody.
Thank you, madam.
Thank you. Thank you.
Thank you, ma'am.
Hmm.
I had
Thank
a
you, ma'am.
question, ma'am.
Thank you.
Thank you, ma'am.
Thanks, madam.
Thank you.
Thank you so much, madam.
Thank you, madam. Thank you.
Thank you, ma'am.
Thank you, madam.
Thank you, everybody.
Thank you so much, ma'am.
Thank
वंदना,
you so much, ma'am.
हाँ, वंदना चैट कॉपी कर सकती है क्या? मेरे को आज चैट बॉक्स भी नहीं दिख रहा है.
Thank you, ma'am.
जी जी.
Thank you, ma'am.
Thank you, sir. Thank you, ma'am.
Thank you, ma'am.
थैंक यू मैम.
Thank you,
अगर
ma'am.
कोई ऐतराज ना हो, आपत्ति ना हो, तो किसी को एक मैं 2 शब्द बोलना चाहूंगा सर. मैम.
नहीं सर, मीटिंग खत्म करते हैं अभी.
नहीं सर, मैं आज ही ज्वाइन किया है सर, न्यूली फर्स्ट टाइम आपके यहाँ ज्वाइन इसमें. तो मेरा भी एक व्हाट्सएप ग्रुप है लॉ से संबंधित ही. तो बस यही कहना
आप
चाहता
मेरे
था
को
साहब.
सर आप मेरे को मैसेज कर दीजिए.
क्या सर?
आप मुझे मैसेज कर दीजिए. हाँ हाँ
मैसेज यहाँ कहाँ करें सर?
हाँ, आपको वंदना मैडम
हाँ सर, इसमें
ज्वाइन हुए हैं ना, आप ग्रुप में ज्वाइन हुए ना, उसमें नंबर है.
नहीं, ग्रुप में तो नहीं हूँ मैं, तो इसमें देखा था मेरे पास किसी ने ये लिंक सेंड की, तो मैंने
अच्छा,
अभी जस्ट 2 मिनट पहले ही ज्वाइन
दिव्या
किया
आपका
है.
नंबर चैट बॉक्स में लिख दो.
और सर मैं एक चीज और कहना चाहूंगा, इसमें जैसे हम वीडियो पर क्लिक कर रहे थे अपना खुद का कैमरा, तो आप बता रहा था कि होस्ट की तरफ से ये डिसेबल्ड है सर, ऐसा कोई इश्यू आ रहा था? हमारी साइड से हमारा कैमरा ऑन नहीं हो रहा था.
वंदना चैट बॉक्स खोलना जरा. चैट बॉक्स खुल रहा है तुम्हारे?
खुला.
हाँ कॉपी कर, चैट कॉपी कर थोड़ा। किया कॉपी?
सर मैंने जो स्क्रीनशॉट था वो सेंड कर दिया सर मैंने। सर
हुआ वंदना?
मैम
हाँ
सर
मैम, कर रही हूँ।
सर आप देख पा रहे हैं सर? स्क्रीनशॉट था वो मैंने सेंड कर दिया सर। यू कैन नॉट स्टार्ट योर वीडियो बिकॉज जस्ट लास्ट में मेरा ही सर स्क्रीनशॉट है मैसेज में
I'm done.
एवरीवन।
Can leave the meeting now.
हो गया?
सर
कॉपी हो गया?
Yes ma'am. Yes ma'am. Yes.
वो ईमेल में कट पेस्ट कर देना मेरे को।
Sure ma'am. मैं करती हूँ।
ठीक है।
Okay ma'am. Good night ma'am.
गुड नाइट।
सर ये स्क्रीनशॉट देखे सर आपने जो मैंने लास्ट में सेंड किया है सर
सर आप
मैसेज
मुझे आप
एवरीवन।
कांटेक्ट कीजिए, मैं आपको बताती हूँ।
आप चैट में आपका नंबर डाल दीजिए। हाँ सर।
नहीं चैट में ये मैंने स्क्रीनशॉट सेंड किया सर, मैं समझ बैठा। यू कैन नॉट स्टार्ट योर वीडियो बिकॉज द
जी
होस्ट है डिसेबल्ड इट।
सर इतना बात नहीं कर
ये मैंने
सकते।
कैमरा और जब ऑन कर रहा था उस पर ये क्लिक ऑप्शन आया सर।
तो वो कोई टेक्निकल इश्यू होगा उसमें, आप मुझे